Okay. These are the briefs for Chapter 6. I'm just going to go over these cases. Hopefully, this will help you in briefing the cases and preparing for the exam. The first case we have is Miranda versus Arizona, which is one of the most famous cases that the Supreme Court has placed upon us. And so, where I'd like you to focus when you brief this case is taking a look at the reason or the purpose that the court is establishing these protective practices that they put in place. And what should be noted is that they are placing the burden on law enforcement. And if you notice in many other areas, they're very slow to place additional burdens on law enforcement. For instance, search warrants. There's no requirement in a search warrant that someone has to be provided an admonishment when it comes to detentions, when it comes to voluntary encounters. Again, the court is not going to place upon law enforcement any specific responsibilities, but here they do, and they do because they recognize that, number one, oftentimes officers have taken somebody and placed them in what the court identifies as a coercive environment. So another way to look at it is the courts places people in an intimidating environment when they place or take someone to a police department. And they're at a disadvantage in the sense that they're not free to leave, that most citizens don't have a lot of contact with law enforcement in that way. So they can be easily intimidated by the entire situation. So the court uses terms like coercive environment. And the court also talks about law enforcement's specific purpose in attempting to extract a statement from individuals. So their approach is that organized and prearranged in the sense that these officers are taught how to interrogate. They use different interrogative methods. And so the court's trying to create an environment where an individual is not necessarily, it's not that they discourage people from talking to law enforcement. They want to ensure that if someone talks to law enforcement, it's done because they've chosen to do it, that they're not being coerced, forced, intimidated into saying something that they otherwise would have chosen not to talk about. So Miranda, you've got 3 questions. And the first one is, what is the purpose of the interrogation environment and why is it created? And its purpose is to get an individual to talk to them. Take a look at what the court specifically says when it talks about subjugate the individual or move the individual to the will of the officer. The second question is, why does the court impose proper safeguards, and specifically under the Fifth Amendment and the Sixth Amendment? The court's doing that in order to give people an opportunity to reflect and ensure that if they do want to talk to law enforcement, that it's done freely and voluntarily. All right, so let's go to the next one, which is Arizona versus Fulminante. And in Arizona versus Fulminante, let me see. So he is, this defendant is suspected of molesting a child in Arizona, and his cellmate was an FBI informant. And this informant, in talking to the suspect, tells the inmate that he would protect the inmate if the inmate was to tell him what actually happened. So this is a form of coercion in the sense that we don't know whether the inmate saying something because they wish to do it freely and voluntarily, and because this guy is an FBI informant, or 2, whether or not he's saying something because of a legitimate fear that others are going to try to kill him. And so keep in mind that if you're arrested for or in custody for sexual assault charges, it is not uncommon, and it's a true risk that people inside in custody will try to harm you if they find out why you're in custody, and they up to including trying to kill you. So the threat is real. And this court, first of all, the fact that this guy's an FBI informant means that he's an agent for law enforcement, which means that he acts as if he's the court will treat him as if he's a police officer in the sense of his actions. So a police officer could not go into that cell and say, I will protect you if you tell me the truth. Clearly, on its face, we can say, yeah, that's coercive. But the court's going to treat this FBI informant the same way. And so what the court says here is that clearly this promise to protect the individual is a form of coercion. And so take a look. The court gives you a specific definition of coercion, which is help you give some insight as to what the court's looking for when it comes to what they're looking for to make sure the officers are not forcing people to make confessions. All right. In Cupp versus Texas, you have, let's see, you have police officers that pretty much do everything wrong that you can think of in trying to talk to this young man. He's 17 years old, which right there is a red flag. Secondly, they tried to get a warrant and it failed. So that alone tells you that they don't have enough information to get beyond probable cause. But yet they show up. Look at the time that they show up. The father lets him in the room. The 17-year-old wakes up to a flashlight in his face, police officers in his room, very intimidating. And then they take him to the police station in his underwear. Excuse me. Which today, if I saw that in a police report, I would walk away from that confession, period. There's no excuse for that. But this is my own personal opinion, is that I think these officers were trying to intimidate him. And one way to intimidate somebody is to give them a sense of vulnerability. And anybody who, if you're out in public in your underwear, most people are going to feel intimidated by that, especially at 17 years old. So if you go through and look at what these officers did, they did everything wrong that you could possibly think of in coercing and intimidating somebody into a confession. And so this case, I'm asking you to do a couple of things. The court talks about being seized, but the court also gives you a specific list of different activities or actions that the officer can take that the court will look at, an officer or officers, the court will look at their behavior to determine whether or not their behavior is being coercive. So it's not necessarily what they say, but it can also be what they do. They look at the totality of the circumstances. The number, it's not just, for instance, the number of officers, but where officers are positioned. So you can have a lot of officers present at a location, and the court's going to say that that's not coercion. But it can be more about where the officers are positioned and how they handle themselves when they're together. All right. So the next one that we want to talk is Howells versus Fields. Howells versus Fields, I think, is an excellent case because, and I've talked about this before, in Howells, the guy's already in custody. He's already in custody. He's in prison, and they are asking to talk to him, and so he's escorted into a conference room, but they don't Mirandize him, and they don't block the door, and I'm not sure if they tell him he's free to leave. I'm pretty sure they tell him he's free to leave. And so they have a conversation with him, and then he makes incriminating statements that they later on use against him in a courtroom. So the question becomes, well, Miranda requires Miranda rights are required if the person's in custody and they are being interrogated. So clearly he's being interrogated by the officers. The question for this case is whether or not he's actually in custody for the purpose of Miranda, not whether he's just actually in custody, because clearly he's in custody, he's in prison. He's not going to go out, go home, buy a cheeseburger. He's in prison. He's stuck in prison. And yet the court looks at this. Remember, the court's looking for a coercive environment. And pay attention to what the court says about Fields, the fact that he's in prison, the fact that he's had law enforcement contact before. So he's not as easily intimidated as, say, somebody who's never had contact with law enforcement. He's in custody. So many of those factors that we would identify as being coercive or intimidating to somebody don't exist for Fields. So that's interesting. So focus on that when you read the case. And then the other thing to focus on is the court says that he's not in custody for the purpose of Miranda. So the word custody has a different meaning for under Miranda, and it has a different meaning if you're just using the term, generically. So clearly he's physically in custody, but what this court says is he's not in custody for the purpose of Miranda because he was free to walk away. He was free to walk out of the conference room, walk back into the general area, walk back to his cell. He was free to leave. And so the court says that he was not in custody for the purpose of Miranda, and therefore he is, Miranda doesn't apply. And I just noticed that I cut off part of the, question for B, but if you take a look in the files, you'll get the full question. So, all right. Rhode Island versus Ennis is an interesting case for two reasons. So in this case, he robs a taxi driver. He's arrested. He invokes his rights, and then he's handed over to two officers for transportation. And the officers talk to each other. They don't talk to him. There's another case called the Christian burial case. It's a case out of Texas. And in the Christian burial case, this guy is already in custody, and they suspect him of killing a little girl. And they can't find the body of the little girl. These detectives know this individual. They know his history. They know that he's, one, crazy, but two, he has some very strong religious beliefs. He is currently detained out of county. And so they are going to go pick him up. And so his attorney finds out that the officers are going to transport him from this other county back into the county of interest. And so the attorney contacts law enforcement and says, hey, I represent this guy and you are not to ask him any questions. So they pick the guy up. They put him in the back of the patrol car, just like this case. They're driving him back to the county of interest in Texas. They don't talk to him, just like in this case, in the Rhode Island case. But they do talk about wanting to give the little girl a Christian burial. And they have this long conversation about how the family is very religious and how the family deserves to be able to bury their child and have some finality, and how important it is to have a Christian burial. And so the guy says, okay, I'll show you where the body is. And so the guy shows them where the body is. They collect evidence. They find the little girl. They use all that information at trial to convict him. Just like in this case, you have two officers in the front seat. They're not talking to the individual. The individual has either invoked his rights or their attorney has invoked their rights. So you have Fifth Amendment issues. You got the Fifth and the Sixth Amendment applying here. You got Miranda applying. And in both cases, the individuals decide to talk. In the Christian burial case, the court said that these two officers knew the individual, knew what he was all about, and the court determined that the officers were manipulating this guy and were circumventing the Miranda. They threw out the evidence, and they found the officers to be in violation. In the Rhode Island case, they found the opposite, because they said these officers did not know this guy, and therefore the court could not say that these people were trying to intimidate or circumvent Miranda, and they had no idea whether this guy was going to respond. And so they found in the opposite direction, saying that Miranda did not apply, and they were able to use the evidence against the individual in this case. Okay, so this is the first 5 cases. There will be a second video with the other